Hello, my name is Dustin Thompson with Delaware United.
Hi, I'm Lisa Minutola. I'm the Chief of Legal Services with the Office of Defense Services.
And today we're going to talk a little bit about the pretrial reforms that are currently underway that we've been working on with Delaware Center for Justice, the Unitarian Universalists, and a number of other organizations, the Coalition to Dismantle the New Jim Crow, a broad support system working on bettering our criminal justice system. So why don't you tell us a little bit about where we were before this reform action started?
Well, what I would see as someone who works for the Office of Defense Services, which is actually the Public Defender's Office in Delaware. We do both the traditional Public Defender's Office clients as well as the Office of Conflicts clients, people who need an attorney outside of our office because of a legal conflict. So as a result, we represent indigent clients by nature of our business. So that's people who cannot afford to hire an attorney on their own because they don't have sufficient funds. And so a lot of our clients who are indigent are also incarcerated because they cannot afford to post bail, even a relatively small amount. So even $100, $200, $300, they don't have the funds to either post that bail on their own or to have resources for a family member to post that with a bail bondsman. So sometimes for low-level offenses, they'd be held for weeks or sometimes even months, and in extreme cases, years, even sometimes for misdemeanor matters.
Yeah, and for those who don't know, they're being held in the general prison population, right? It's not a separate, we don't have, unlike other states, we don't have a separate system for pretrial detention.
Well, correct. There's not like a separate county jail or a separate facility.
Right.
They would be held at one of the state prisons. There is pretrial population, so I believe the Department of Corrections does have some separation of the pretrial inmates versus the sentenced inmates. But yes, they are in the same facility as the sentenced inmates.
Right. So why don't you talk a little bit about what HB 204 did, which is what was passed earlier this year?
Yes. House Bill 204 was a bill that came from a coalition of state agencies and community partners such as the Delaware Center for Justice, who really was the, I would say, the leading advocates on that bill because they went out and got a grant in Delaware to look basically at our pretrial system and how it's run in Delaware. And we saw a lot of flaws. We saw this issue of people who were detained pre-trial who didn't necessarily pose a risk to the community, but because of the fact that they were indigent and were too poor to pay their bail, would end up being incarcerated, while at the same time, some individuals who potentially could pose a risk to public safety but had funds to post their bail were released. And so we wanted to look at the system and really have less of a reliance on money, on monetary bail, as the way in which somebody would be detained, and really look more at the risk factors. So Delaware already had a risk assessment tool that was implemented a few years ago with some other reform efforts in Delaware. But we looked at that tool and it needed some changes. It didn't quite validate properly for our population. So the Delaware Center for Justice and the other partners, including the Justice of the Peace Court, really worked with some leading research experts to create a new tool called the DelPat, which will do a better job at gauging somebody's risk to either reoffend or to not appear for court while they are out on release. And so the court is going to be implementing and using that DelPat to come up with a risk score that will guide what the judges do, but not necessarily be the end-all, be-all determination, because judges still have to use their own common sense, their own discretion, and look at the facts of each case and each individual to determine what the appropriate bail would be. What House Bill 204 did was put less of an emphasis on money being the only way that somebody could be released. It really puts an emphasis on looking at other conditions within the pretrial system or within the community to release that person. So it could be for something as little as just have no contact with the victim to something as serious as having a pretrial supervision officer that you're going to meet with on a regular basis once you're released in the community. So it kind of figures out what conditions can we release you on to assure public safety, but also assure your liberties. It's kind of a balancing act.
Right. And there was no fiscal note involved with that bill, correct?
I don't believe there was any fiscal note with 204.
So
we're using existing resources for 204, I believe.
Correct. Yeah. So that's one of the big differences between this one, 204, and the bills that are coming down the line now with the constitutional amendment. Right? We're introducing a new additional alternative to bail, correct?
Correct. So with the constitutional amendment and then some enabling legislation to effectuate how we're going to do what we're going to call preventative detention. There probably will be some fiscal notes with that because there'll be some additional resources that will be needed. Right now in Delaware, the Constitution says that basically all persons, except for those on capital offenses, are entitled to bail. And right now in Delaware, we don't even have any capital offenses because that would be basically capital murder. And as of right now, Delaware does not have a constitutional death penalty statute. So all people are entitled to bail. So in order to do a preventative detention system, which means that you're going to be held without bail either until your trial is completed or till some other point in the process that'll be determined by statute, we have to amend the Constitution, which is a two-session cycle requirement. It has to pass through 2 various general assemblies before it can actually become into effect. So the constitutional amendment will allow preventative detention. The enabling legislation will basically detail what the circumstances are that somebody could be held without bail. And there's going to have to be things like a high standard of proof, which we call proof positive or presumption great, that the actual offense occurred, and then also clear and convincing evidence that there are no circumstances or set of circumstances by which this person can reasonably be released into the community without giving the court some kind of feeling that this person would not pose a risk to the persons involved, public safety, and that they will come back to court. So that's really what preventative detention.
And one of the main focuses here is 1, public safety,
Yes.
and 2, an equitable criminal justice system that doesn't rely as heavily on financial bail.
Correct.
And more on these pre-trial supervision measures or being released on your recognizance, or the other extreme for extreme offenses, the pre-trial detention.
Correct. It's getting away from the idea that money equals safety, because it does not. Just because you are rich enough, if you will, to afford to post bail doesn't mean that you're any less of a public safety risk than somebody who is poor and cannot post their bail.
Right.
So it wants to look at more objective factors than your ability to make a certain bail amount.
Great. Well, thank you so much for taking the time this morning to talk with us.
My pleasure.
Thank you all for watching at home. I hope that we can count on your support and all the organizations that will be helping push for this effort to make a more equitable system for all of Delaware. Thank you again very much.
Thank you for having me.